In a landmark judgment on Tuesday, the Supreme Court issued guidelines for death sentence convicts. It also commuted 15 death penalties into life imprisonment. Ms. Anuja speaks to Yug Mohit Chaudhry, the lawyer on behalf of the 15 death convicts, about the judgment.
Hi, Yug. So, Yug, if you can just simplify for us, what exactly has the Supreme Court said today?
Oh, they've said many things. One thing is, they've said that every prisoner, even a death sentence prisoner, till his last breath has rights which have to be protected by law. That's one. Then they have said that a prisoner has every right to come to the court complaining about delay in the disposal of his mercy petition. And if there is unexplained and excessive delay in the adjudication of his mercy petition, then his death sentence will have to be commuted. They have said that executing prisoner with mental illness violates constitutional morality and the evolving standards of decency. They have said that retribution has no place within constitutional values. And then they have commuted all the 15 cases of all 15 prisoners. Then they have given elaborate guidelines to the government, which include that provision of legal aid to the prisoners at the time of making of the mercy petitions as well as after the rejection of the mercy petition. They have said that at least the rejection of the mercy petition should be communicated to the prisoner and to his family, and that there must be at least 14 days gap between the communication of the rejection to the prisoner and the family and the date of execution. You cannot execute a person without communicating in advance to him and his family. So, that would have, now of course what they did to Afzal Guru can never happen again. They have said that post-mortem should be carried out after each execution to see whether the execution was done properly or not. It's one of the judgments which is a great tribute to the Indian judiciary, to the independence of the judiciary, to our constitutional values. It is a judgment, according to me, which will be cited around the world, and it will be, I think, a guiding light for other courts around the world in the evolution of death penalty jurisprudence.
You tell us something. What led to this petition? Can you give us a brief?
In the last 1 year, Pranab Mukherjee rejected 20 mercy petitions. Out of the 20, 2 of the prisoners were executed silently and secretly, Kasab and Afzal Guru. The other, where we got to know about the rejections, we moved the court and got stay orders in the course of the year. So all the 18 other executions were stayed. Since the cases of 15 prisoners were heard together. That's how these cases came to the court, because we moved the court and first asked the court to stop the execution because of various grounds we had in our favor. And then after the court stopped the executions, when the hearings took place now, all of them together.
Okay. What do you think will be the biggest takeaway from this judgment?
Many things are there, including, of course, the delay, the fact that delay is a ground for commutation, that prisoners have rights which have to be protected, that the government has to treat these prisoners with humanity and decency, that insane persons cannot be executed, that there has to be a post-mortem done after each execution to see whether the execution was properly carried out, that legal aid has to be provided. It was a huge judgment. It's a big, big judgment, and as I say, it's a tribute to the independence of the judiciary, to the evolving standards of decency as identified by the judiciary, and to our constitutional values from which this judgment emanates.
Okay, thank you.
Okay.